Welcome to Legal Angle with Emmanuel the Law Olawale. Thank you for joining us on this episode. I have with me today a special guest, Judge James Green. He's not just a judge, he's someone you can call a social engineer, mentor to lawyers, established lawyers, and even new lawyers and students. It's someone that you would love to be in his courtroom, if only to know how the judicial system works. Thank you for coming on the show, Judge Green.
Thank you for inviting me. I was looking forward to this all week.
Oh, wow. I was looking forward to it too. And can you tell us a little bit about yourself for those who don't know who you are?
Well, I grew up in Akron, Ohio, about 2 hours north of here. And when I was growing up, I had aspirations for my career. I wanted to be a carpenter. I loved working with my hands, I loved building things. And so instead of going to my neighborhood high school and maybe preparing for college or otherwise, I went across town to a vocational high school to study carpentry. I took no college prep courses because I had no interest in going to college. The youngest of 5 children, raised by a single mother. I had 4 older sisters, none of whom had gone to college. So when I graduated from this high school, my mother came to me and said, "Son, I need for you to go to college." And I looked at her and I said, "What do you mean you need for me to go to college?" She said, "Well, none of my girls went. I need to have at least one child that I can say went to the university." She said, "I don't need for you to graduate. I just need you to go over there and take 2 courses, and I will then leave you alone." Well, as it turned out, my mother played me. I mean, she played me. She knew that I had a habit of finishing the things that I started. And in her mind, if she could just get me on someone's college campus, she knew the rest would kind of take over. So I went to the local university, University of Akron, took those 2 courses. One was an introduction to psychology course, and it changed my life. I was so interested in the subject matter, I figured, well, just out of interest, I'll take some more psychology courses. And after a couple years of doing so, while building cabinets to pay my way through, I ended up majoring in psychology, thought I would go on and get a master's and a PhD in clinical psychology and become Dr. Green. And a funny thing happened as I'm approaching college graduation. I go see my advisor to talk about getting into an accredited graduate program in psychology. And she's looking at my transcript. Now, if I'm honest and if I can be transparent, and some members of the audience may be able to relate to this, I did not set the academic world on fire when I was in college. And she recognized that, and she seemed to want to hone in on the not so great grades that I received rather than the courses I did well in. And she discouraged me from even applying to a graduate program in psychology. I then said to her, "Well, I had a crazy thought of maybe applying to law school." And she looks back at me and she laughs. And she says, "Yes, that is kind of crazy, you going to law school." She really kind of scoffed at the idea. So I left her office. I was angry. My feelings were hurt. I never applied to grad school. I took what's called the law school admissions test, or the LSAT. I applied to 4 law schools, and all 4 law schools accepted me as a first-year law student. And the rest, as they say, is history. So I graduated law school, took on a job with the Franklin County Prosecuting Attorney's Office, trying the adult felony cases, the rapes, the robberies, the murder cases, capital murder cases. Did that for about 5 years. And then I took a job with the Ohio Supreme Court, which, for the viewing audience and the listeners, in Ohio, the Ohio Supreme Court is the state court of last resort. It's the highest court in the state in our state court system. I took an administrative position there, worked that job for 5 years, and the work I was doing at the time came to the attention of then Governor Voinovich, and I was appointed to the Franklin County Municipal Court as a judge. I've been on the bench for 26 years. Last May, I retired from Columbus State Community College after teaching as an adjunct for 32 years. So it's been a long road. It's been a busy road. It's been an enjoyable road. And I look back on my career, counselor, and I've had opportunities that I never in life imagined ever having. So that's by way of background.
Wow. What a story. Wow, experience. Not having a mentor while growing up, especially not anyone in your family has ever been to college, how did that inform or affect the way you saw college when you started?
It made it much more difficult. I had no idea how to prepare for college. I went to college very ill prepared to be there. I struggled. I struggled with things like reading comprehension. I struggled with how to pay for it financially. I struggled with having classmates, many of whom had their college paid for by parents or other means. They didn't have to struggle or stress over finances, paying tuition, buying books. I tended to buy used books because they were more affordable. I worked full time while in college. That was a challenge as well. So there were a lot of challenges as a first generation college student.
Yes, I can relate to that because I had to do the same too.
Mm.
Studying myself through college, work full time, pay, buy used books, and just make do.
Mm-hmm.
Then, in spite of the difficulty of the disadvantaged background you came up with, you, how did you decide that law school wasn't?
Well, so I really had this thing about psychology. Love the subject matter, the dynamics. And so, I knew there were, okay, growing up, I didn't have any African American role models that were professionals. All of my African American role models were either tradesmen, carpenters, electricians, plumbers, or they were factory workers, the automobile industry, the rubber industry. Akron, Ohio was then known as the rubber capital of the world. All the 5 major rubber producing companies were headquartered right there in Akron. If you couldn't find a job anywhere else, you could always get a job in one of the rubber shops. It was a decent living. It was a very laborious job. It was a very dirty job in most instances. So I knew I didn't want to go in that direction. I loved the thought of fighting for something I believed in, something I could be passionate about. During that time, I came up in the tumultuous late 1960s and early 1970s. Martin Luther King had been assassinated. Malcolm X had been assassinated. The late Senator Robert Kennedy had been assassinated. I lived through the Kent State riots. And so, I had this idea of fairness and justice. I wanted to make a difference. And so the legal profession seemed like a way in which I could do that and have an impact.
That's awesome. And was your mom present when you became an attorney?
She was. And let me tell you something about this woman. I graduated law school, received what's called a JD or a Juris Doctor. I became an assistant prosecutor, and my mother lived probably for about the first 11 or 12 years of my being a lawyer before she passed away. I don't care how long I was a lawyer, you could not tell my mother that I knew more about the law than she did. You would have thought she had a bachelor's, doctorate, and master of laws, because anytime we get into a discussion, which would frequently turn into an argument, she would argue me down on a legal principle that she knew nothing about. And so we would have some knockdown, drag out battles and arguments about legal principles. But she was extremely proud. When I graduated law school, she was right there front and center. When I took a job with the county prosecutor's office, she was there for my swearing in. And kind of a funny story, when I left the prosecutor's office to take the position with the Ohio Supreme Court, I called to tell her about this neat job opportunity I had. And she said, "But you have a good job. Why would you quit one job to go to another?" And understand, her mindset was, you get a good job, you work it for 30 years, and you retire. You don't change jobs. So I got sworn in by the Supreme Court for that position, who was front and center right there with me, my mom. And then 5 years later, when I became a judge, I got appointed by the governor. I called her up in Akron and said, Mom, the governor wants to appoint me as a judge. Her first reaction, but you have a good job. Why would you take on another job? And so when I became a judge and I had my induction or swearing in ceremony, who was there on stage with me to zip up my robe and hold the Bible while I was sworn in? None other than my mother. So she was with me every step of the way. She was very proud of me. One of my biggest cheerleaders for sure.
It was the right place.
Yes, yes.
And after you got appointed to the bench, how was that transition for you? Let's back up a little bit. When you got that call that you will become the judge, how did you feel?
I was a bit surprised. I was honored. And if I'm honest, I was scared to death. Because, as you know, you don't go to school to learn how to become a judge. You practice law in Ohio for a minimum of 6 years, and then you can either run to be elected into a judgeship, or you can be appointed to a vacancy by the governor. And so the appointment came, and I had kind of expressed an interest. It didn't just come out of the blue. I had submitted my name thinking nothing would come of it. And so when I got the call, I thought, oh crap, what do I do now that I've gotten a call? And so you take the job. I remember the first day getting on the bench like it was yesterday. I was scared to death. Got up on the bench, didn't know what to do. My bailiff said, all rise. Everybody in the courtroom stood up. I'm looking around, waiting on the judge to come walking in. And there I am, expected to do the job. So it's on the job training. It's fast learning. Back then, we were handling about 40 to 60 cases a day. Now it's up to 60 to 80 cases a day. So it's baptism by fire. Yeah. You either learn or you perish. And I'm a fairly quick learner. And so I picked up on it. I've been in and out of the courtroom for a number of years. So I was familiar with the environment. I had seen what judges do. Of course, we all think we can do the job better than some people. So I figured, how bad can I be? I'm going to be better than some. I may not be as good as others, but I just kind of rolled up my sleeve, got to work. I had some fellow judges that I could call upon when I had questions. So it worked out. It worked out pretty well.
Yes. And when it comes to even having a Black judge or even Black attorneys, I think you are one of the trailblazers in Franklin County. What was that like for you, being one of the few attorneys of color at the time and possibly judges of color?
Well, our profession, the legal profession, has been heavily dominated by white males for centuries. And we as Black attorneys, myself as a Black judge, we've always had to fight for acceptance. We've always had to deal with certain issues that our white counterparts have never had to deal with. I can't tell you the number of litigants that have come in front of me in my courtroom who did not want to have a Black judge. Some of them shared it with their lawyers. A couple of them actually shared it with me and told me they did not want to have a Black judge and they wanted me to get off the case and reassign it to a white judge. So a white judge has never had to deal with those sort of issues. I've had to deal with those issues both as an attorney and now as a judge. And it's frustrating. It's disappointing that in 2021, we still struggle and fight for acceptance because the playing field is still not a level playing field, whether it's for you as an attorney, and you come into this mix as someone from another country, breaking into the American culture. You have an accent, and so that distinguishes you from anybody else who may look like you, but may have been, an African American. And so there's a struggle there. When you come into my courtroom, I see you walking in the door and I recognize there's a brother who's probably had a tough day so far. Let me see what I can do to help him and his client along their way. That's my immediate reaction when I see you, counselor, walk in my courtroom door.
And thank you for that. I must say from day one, you've been a judge as long as you've been a lawyer. You've been one of those judges who I see as a mentor who makes life and practice easier. Thank
Well,
you.
it's good to hear that because that is in part one of my goals.
Yes. Let's talk about warrants, because as a judge for over 26 years, I'm sure you've issued hundreds or thousands of those.
Yes.
I will assume, I don't want to assume that everyone watching or listening to this knows what a warrant is. So can you tell us what a warrant is?
Okay, so a warrant is a document that orders someone to appear. Now, there are many, many different types of warrants, and there are warrants that are issued for any one of a number of reasons. I'll start off with, let's say, arrest warrants. If you are suspected of committing a criminal or a traffic offense, mostly criminal or traffic, frequently the entity issuing or filing the charge, let's say, and typically it's a law enforcement agency. It's the Franklin County Sheriff's Office. It's the Columbus Police Department. It's the Ohio State Highway Patrol. It's the Ohio State University Police Department, or any one of a number of other jurisdictions, Gahanna Police, Worthington Police, Westerville, Hilliard, Dublin, Bexley Police. Is typically a law enforcement agency and one of its officers who will file charges with you being a suspect. And in many instances, they have the option to either file the charges and issue a summons ordering you to appear on your own voluntarily, or they may file those charges and issue a warrant with the charge. When they issue a warrant, that's basically an order saying whoever finds this person is to bring them before the court as soon as possible. These are arrest warrants. And once it's issued, you either turn yourself in once you recognize that you have a warrant, or you run the risk of being stopped, pulled over, or otherwise questioned. And if it's discovered upon that you have a warrant, you are highly likely to be taken into custody and processed on that warrant. Once arrested, you're taken to some local detention facility where you are what's called slated. That includes being photographed, fingerprinted, and certain other things associated with the processing or the slating of taking you into custody. And then you are held until you can appear before some magistrate or judge for your first appearance, unless it's a charge that has a standard bond, in which case you or somebody can post a bond before that first hearing and be released, and then you can come in voluntarily at what's called that initial appearance or that arraignment hearing. So those are what we'll call arrest warrants. Then you have what some of you may have heard of as bench warrants. As a judge or a magistrate, I can issue a bench warrant ordering someone to be taken into custody for a number of reasons. If they fail to show up for a court hearing, I can issue a bench warrant. If they fail to pay certain obligations where I am authorized to issue a bench warrant, I can do that. If they've been ordered to perform some community service or pay restitution or do some other things that they've been ordered to do and they fail to do these things, frequently I'm in a position to issue a bench warrant. I don't always issue a bench warrant just because someone has failed to do something or failed to show up in court, but I am certainly able to do so in many instances. So we got the arrest warrants, we have the bench warrants. There's other different types of warrants, but those are the two that the average person would most likely encounter. And if I can just kind of expand on, once someone gets arrested and they appear in court, they're entitled to have a bond set in most instances. There are some instances where the court can deny them an opportunity to post bond and secure their release. But in most instances where you're arrested on a criminal or traffic case, you are entitled to receive some type of bond. And bonds can be very confusing for a lot of people because we throw out the term bail, we throw out the term bond, we talk about a bail bondsman, we talk about surety bonds. Well, just if I can just give like a 2-minute tutorial, there are about 5 different categories of bonds that one will typically face upon being arrested. If you get arrested and you come before the court for your initial appearance, what everybody would love to have the judge set is what is called a recognizance bond. And that's basically a signature bond where you sign promising that you'll show up at all future court proceedings and you can then be released from detention without having to post any money. That's a recognizance bond. Then if you can't get a recognizance bond, the bond that most people would then next like to have is what is called a property bond. Property bonds involve someone putting up some tangible physical property, the value of which will satisfy the face amount of the bond. So for example, I get arrested and the judge sets a $10,000 property bond. I have to have some property. It can be a car, it can be some furniture, it can be a house, like a parcel of real estate, but I have to put up some property. Now, of course, if I'm going to put it up and put it at risk, I have to be the owner of that property. So the judge sets a $10,000 property bond. I have to put up $10,000 in value for property. So let's say I have a house, and let's say I have a mortgage on the house. And let's further say that the house is appraised, it's worth $200,000. But let's say I have a mortgage on the house, indebtedness to the tune of $195,000. That would only leave me $5,000 in equity on the property. So I cannot use that property to post a $10,000 property bond, if that makes sense to everyone. In 26 years of being on the bench, I've probably set fewer than 5 property bonds. I don't care for property bonds. And the reason why is because it's typically not the person who's been arrested whose property is going to be put up. It's typically a parent, a grandparent, a sibling, some other family member, coworker, or neighbor who, if you choose not to show up, their property is on the line. And I don't like putting other people in jeopardy of losing their property because of a defendant not showing up in court. So I'm not a big fan of property bonds. If you can't get the recognizance bond or you can't get the property bond, the next type of bond that people would like to have is what's called a cash bond. Now, a cash bond is great because you put up the cash and you get all the cash back when the case is over. That's great. Problem is, you have to have the cash. So if the judge sets a $10,000 cash bond, you post it, you're going to get it back when the case is over if you show up at all future court proceedings. But who has $10,000 cash just sitting around to let the clerk of courts hold until their case is over? So you can't get a recognizance bond, you can't get a property bond, you don't have the cash to put up a cash bond. The next type of bond people would prefer is what is called an appearance bond. Sometimes it's called a 10% bond. In the case of an appearance bond, you put up 10% with the clerk of courts of the face amount of the bond. So again, if judge sets a $10,000 appearance bond, you have to put up 10% or $1,000 with the clerk of courts. Now, the reason they call it a 10% bond is because you get the entire amount back that you posted less 10% of what you put up. So to do the math, Judge sets a $10,000 appearance bond. You put up $1,000 with the clerk of courts. Counselor, how much of that do you get back when the case is over?
$900.
You get $900 back. The clerk keeps 10% of what you put up, or in that case, $100 if you do the math. Lawyers love appearance bonds because the $1,000 that you put up, they know that that's like money in the bank. And if you owe them a fee, there's a readily available pool of money that they can access. And let's face it, a lot of people will take the services of a lawyer, get great results, and then not want to pay the lawyer for the work that they've done. Well, most lawyers do what we call pro bono work. They do their share of pro bono work. They represent certain clients and don't charge them. But the lawyers have expenses. They have a life to maintain. A lot of times they have office overhead. Some of them are still dealing with things like student loans and other obligations. So they're working for a living. So they deserve to be paid a reasonable fee for the services they provide. So that's the appearance bond. The bond that people like the least. And the last category of bond is what is called a surety bond. This is the one that most people are familiar with. It's the one that involves an underwriter slash surety slash bail bondsman. Someone has to guarantee that if you're released, you're going to show up at all future court proceedings, and that if you don't, they agree to be held accountable for you not showing up. So let's work this through. Judge sets a $10,000 surety bond. You would then need to find a bail bondsman who's going to guarantee that either you will show up or they will be on the hook for the entire $10,000. Now, they're going to charge you a fee for performing this service. And the typical fee that a bail bondsman will charge is 10%. So judge sets a $10,000 cash or surety bond, a $10,000 surety bond. You're going to find a bail bondsman, and they're probably going to ask you to pay them $1,000 or 10% of the $10,000 surety bond. The $1,000 that you pay the bondsman, that is not refundable. You don't get that back. That's the bail bondsman's fee for assuming the risk in the event that you don't show up. If you don't show up, the court will then initially go after the bail bondsman, issuing a, what kind of warrant? A bench warrant. Issuing a bench warrant for your failing to appear. They'll then look to the bondsman to either find you and bring you before the court or to fork over the entire $10,000. Now, let's say the bondsman can't find you. You've concealed yourself in somebody's apartment, under somebody's bed, and nobody can find you. So the bail bondsman now is on the hook for the entire $10,000, only $1,000 of which have you given them. So they're going to try to track you down because they don't want to have to pay the $10,000 to the court. So they're going to try to find you. And if they cannot find you, they're probably going to enlist help. And they're going to enlist help from someone known as a bounty hunter. A lot of you have heard of bounty hunters. You've watched the show, Dog the Bounty Hunter, and there's other shows out there. And so the bail bondsman will partner with the bounty hunter. They will pay the bounty hunter to help track you down. And the bounty hunter will probably charge the bail bondsman the 10% that you paid the bail bondsman. And that's the bounty hunter's fee. The bail bondsman will not get that $1,000 back from the bounty hunter if they find you. So that's kind of the way this whole warrant, arrest warrant, bench warrants, and the bonds associated, kind of how that works.
Thank you. What happens in a situation where someone came in, posted a bond, and then, they are free to go? Then the next time they fail to appear in court, then let's assume that they get arrested by either the police or a bounty hunter. And in that situation, are they still eligible for another bond? Or that's it?
Yes, they're still eligible to have a bond set upon being arrested, let's just say the second time in this case.
Okay.
But most judges, seeing that the bond that was posted initially was not sufficient to bring them into court, is probably going to set a different amount, maybe a different type of bond. If the judge initially set a $10,000 cash bond, surety bond, or appearance bond, or let's say the judge authorized their release on their own signature and gave them a recognizance bond, when they fail to show up, the judge is probably going to set a much higher bond. The judge is probably going to make it more difficult for them to get out of jail and come in voluntarily because they've demonstrated that they can't be trusted just to come in on their own. Exactly.
So let's assume that if the second time they showed up in court throughout the life of the case, do they get all the bonds they posted back, or do they only get the first one or the second one back? Or
it depends on what type of bond it is. Let's say the judge initially sets a $10,000 cash bond, and they put up $10,000 and they don't show up. Judge issues a bench warrant. They then get arrested. They're brought to court. The judge then sets, let's say, a $20,000 cash bond, and somebody posts, kind of crazy, but somebody posts $20,000 cash. They show up for every future court appearance. They get the case resolved. Well, the $20,000 is going to go back to whoever deposited it, and the $10,000 is going to go back to whomever deposited it.
Okay. For traffic cases, most traffic cases, let's assume fines. Let's assume fines maybe up to $1,000. Most of them are less than that. Why do judges issue warrants for cases like that?
On traffic cases?
Yes.
Well, here's the problem. Let's say you get charged with a routine, minor misdemeanor, non-serious traffic matter. Let's say you're charged with doing, 45 miles per hour in a 35 mile per hour zone. It's a speeding charge.
Correct.
You are exceeding the speed limit by 10 miles per hour. You weren't driving crazy. You weren't driving recklessly, but you were exceeding the speed limit and you get charged with speeding. You have a court date. You don't show up. Let's say you show up for your court date. Let's say you decide, okay, I'm guilty. I was driving 10 miles over the speed limit, and you enter a guilty plea instead of having a trial. Or let's say you deny your guilt and you choose to exercise your right to a trial, but you're found guilty by the court at the conclusion of the trial. Either way, you wind up with a conviction on your record for speeding. Now the judge is put in a position to pronounce a sentence.
Correct.
In that case, the most the judge can do is impose a monetary fine and court costs. The BMV will assess the appropriate number of points against your driving record. Judge has no authority over that, but the judge can set a fine and court costs and set a date for payment. I have to impose some sort of consequence upon the conviction. If the maximum fine on that speeding charge is $150 plus court costs, I can set a $1 fine, I can set a $150 fine, and anything in between. Now, having said that, apply your question to that scenario.
Okay. In a situation like that, where let's say you can't afford to pay the fine, what are the consequences of that?
Well, when you say can't afford to pay the fine,
let's assume you didn't pay the fine.
Well, what are we assuming? You can't afford to pay it, or you simply did not pay it? Those are two different things. Now, let's say you can't afford to pay it, to your first question.
Yes.
We have provisions now where a judge can authorize you to perform some community service in lieu of having to pay your fines and court costs. And there's a formula. How many hours represent how many dollars towards your fines and costs. So that's an option. Another option is the judge can simply find that based on your indigency status or your poverty status, your inability to pay, the judge can suspend the fines and costs after imposing them making a finding that you are unable to pay. So there's options there for the court.
Okay, let's get back to that case scenario. You got a ticket for speeding, let's say 25, 45 in a 25-mile zone. You are supposed to appear in court. You didn't show up. A judge issues a bench warrant. And eventually, you have to post a bond of $1,000. Meanwhile, the fine for the ticket will have been about $100. How do you explain that to folks out there?
How does who explain it? Their lawyer? The judge? How does who explain it?
Educate, I want you to educate anyone watching or listening to this, why things like that happen.
Well, again, you had a bond because you were, no. I started to say because you were found to have committed a violation. No, the bond is posted before there's even a determination of your guilt or innocence.
Correct.
So court sets a bond. The bond gets posted. You're convicted of that charge. Well, now there's a consequence now. If the judge imposes a fine and court costs, depending on what type of bond it is, the amount posted might be available to satisfy the fines and court costs. But if it's not sufficient to satisfy that, you're on the hook for the fines and court costs as a consequence of your being found guilty of committing an offense.
Okay. How can someone find out if they have an outstanding warrant in Ohio?
If you think or you're questioning whether you have an outstanding warrant, my suggestion is you get in your car, you get on the interstate, and if the speed limit on the interstate is 70, you should drive about 110 miles an hour, get yourself pulled over, and you will then learn from the police officer who pulls you over whether you have an outstanding warrant. I am really just kidding. You can, in many instances, you can go online and look up your name and find out if there's an outstanding warrant pending against you. You can call the clerk's office. I mean, there's ways you can find out without just assuming and turning yourself in.
Okay. Have you ever had a situation where someone fails to show up to court at the appointed time and you already issued a bench warrant, then they showed up maybe an hour or 2 hours later and approached the bench or the prosecutor or whoever is in charge of the bailiff, and you had to lift those warrants before it became before you leave the court?
They've asked me to lift a warrant, or I've had to lift a warrant.
They asked for you to lift the warrant and you had to, or have you ever had a situation like that, or it's impossible at the moment you're late?
It happens all the time, daily. There are people that will show up an hour late, 2 hours late. Case set for 8:30. Some people will show up at 1 o'clock in the afternoon. Case set for 8:30. Some people will show up the next morning. Case set for 8:30. Some people will call in at 4 o'clock in the afternoon. I think I had a court date this morning. I'm not sure. Could you tell me if there's a warrant? We have all those scenarios. Now, my attitude is if you have a court case at 8:30 and you show up 2 or 3 hours later after I've issued a warrant, by virtue of your showing up, even though you're late, it says to me you are not trying to hide, run, or dodge the case. Now, first thing I'm going to ask you is, why were you late? Well, I overslept, or I had an emergency. I had to take somebody to the hospital, or I had to work overtime and I couldn't get off work. I thought the court date was tomorrow and my mother called me and told me it was today. People are late for any one of a number of reasons. I'm listening to the reason. Now, you tell me that you had to work overtime and your boss wouldn't let you off. I'm going to pretty readily vacate or lift a warrant and see if we can resolve the case or give you another court date. You tell me you had a medical emergency or somebody in the family had a medical emergency you had to tend to. Same thing. I went out of town for the weekend. I had a court date on Monday morning. I was coming back and my flight was delayed. My train was delayed. My bus was delayed. It happens. Imagine if you're on a cruise ship and while out to sea, there's an outbreak of some virus and the cruise ship is quarantined. There had to be some of those people who had court dates that they missed because they're stuck out in the middle of the Atlantic Ocean. And so they come back and they say, I missed my court date 2 weeks ago, 3 weeks ago, because I was quarantined. Well, if they were truly quarantined on a ship, they're going to have some sort of documentation to verify that. And I'm going to ask them for documentation. You tell me you had a medical emergency and had to go to the hospital. Well, they give you what's called discharge papers. Bring your discharge papers in. I can't argue when you bring in discharge papers. So depending on what excuse they give me now, let me say this. They give me an excuse or a reason why they were 2 or 3 hours late. I look at the file and I see they've been late or a no-show 2, 3, 4, 5 other times. Well, that coming in late, it only lasts or works as an excuse just so many times. But if you're showing me that habitually you don't show up when you're supposed to or you show up late, I'm not going to be as sympathetic as I would to somebody who does not make this a habit.
What are the procedures to go through if you want to get a warrant after you find out that you have an outstanding warrant against you?
You say, where do you go?
What are the procedures? What do you have to do?
Well, if you have a lawyer, you contact your lawyer and let him or her know, and they will then take care of it for you. Because if you have an attorney, the court is not supposed to be having a conversation with you. The bailiff should not be having a conversation with you. The prosecutor should certainly not be having a conversation with you if you are represented by an attorney. And if we have a discussion or a dialogue with you, knowing that you have an attorney, we could all get in trouble for that. If you do not have an attorney, then you can contact the prosecutor's office and see if they will agree to have the warrant lifted. And if they'll agree, the court is more likely to lift the warrant if there's no objection from the prosecution. We have an offices that we call court services. Used to call it court investigations. And you can always go to that office for the municipal court. I don't think they have a similar office in the common pleas court, the juvenile or domestic relations court, but in the municipal court here in Franklin County, we have a court services office, and you can always contact that office and they can tell you if in fact you have an outstanding warrant, depending on who the judge is. We have 15 judges in our court, the Franklin County Municipal Court. And there's a lot of procedures that we handle in a uniform, similar sort of manner, but there are other procedures that differ or vary from one judge and one courtroom to the next. So, we all have different procedures that we employ to address those sorts of things.
Thank you. Does a defendant have a right to request a hearing about the warrant?
Does a defendant have a right to request a hearing? Let me kind of backdoor my answer to that question. A defendant has a right to request a hearing for anything that they want to request a hearing on. They're not entitled to have a hearing, but they can certainly request a hearing, and it'll be up to the judge's discretion whether to grant their request. Excellent question. Excellent question.
And does every defendant needs an attorney to get a warrant lifted? Let's assume that a defendant cannot afford an attorney. Is this something they can do on their own?
They can make the request on their own without an attorney. It's made easier when you have an attorney because the attorney knows the process and procedures for doing so. But no, if you are not represented by counsel, let's say the situation where you have a traffic ticket and you missed a court date and there was a bench warrant issued. To hire a lawyer and pay the lawyer $200, $300, $400, $500, when the most that's going to happen to you is a fine and court cost if you're found guilty, it doesn't really make sense to spend good money after bad, because you end up spending more money to pay the lawyer than you would to pay any fines and court costs that might be assessed.
Can a warrant be appealed?
A warrant cannot be appealed, but a warrant can be challenged. You can always challenge the issuance of a warrant, but that by itself is not generally an appealable issue.
How about a bond?
You can challenge a bond. If a bond is set and you're dissatisfied, you don't like the bond, or you can't make the bond, you can always ask for a bond hearing or a bond reconsideration. And it's up to the judge's discretion. The judge who set the bond, it's up to their discretion whether to modify the bond.
Okay. And what are the factors you consider when modifying or setting a bond?
Well, let's just talk first about setting a bond. There's a criminal rule that sets out the criteria for setting a bond. And the purpose of bond, contrary to popular belief, is not just simply to keep people in jail. The purpose of a bond is to try to ensure that that individual is going to show up at all future court proceedings. So if a person has a track record of always showing up for court when they're supposed to, then I don't need to be real concerned about setting a high bond or a bond that's otherwise going to be difficult for them to make to secure their release. I give them a signature bond because they always show up for court when they're supposed to. They may have a lengthy record, but that doesn't faze me as much as, in spite of their lengthy record, do they show up for court when they're supposed to? Another criteria that's listed in the criminal rule: if released from jail on bond, are they going to pose a risk of harm to themselves or to someone else? And if I'm concerned about that, then that's going to determine in part what type and amount of bond I set. Let's say I have a truck driver, lives in California, is driving through Ohio to deliver a load somewhere in Ohio or east of Ohio. And let's say that person picks up an OVI, a drunk driving charge, while driving through Ohio. They get charged and the judge needs to set a bond. They don't live here. They don't come through Ohio on a regular basis. So I then immediately become concerned about whether they're going to be a flight risk, or what we might call an absconder, or in the most simplest of lay terms, simply somebody who's not going to show back up if I agree to have them released because they live 3,000 miles away. That's going to influence the type and amount of bond that I set.
Thank you. What happens in a situation where a defendant turns himself into the police? Does the police have the authority to release them or determine how much they'll pay in bond?
No, that's not up to law enforcement. And I've gotten calls in the middle of the night where the police arrested someone who had an outstanding warrant on one of my cases, and they'll go to pick them up. For some reason or another, they found them at their residence. Maybe there was a call, and they'll go to pick them up, and they'll find that that person is at home with 3, 4, 5 children, small children. And let's say they were not charged with a real serious offense. Well, the police officer is thinking, there's an outstanding warrant. I could arrest them right here now, take them to jail, but if I do, I then have to cart these children off to child welfare, unless there's another family member, neighbor, or somebody who's willing to come over and step in. And the police will generally give this person an opportunity, if they intend on arresting them on this outstanding warrant, a chance to call somebody to come over and look after the children while this person is handling their court business. I've had officers call me, they've gone to arrest somebody, and the person has been injured. And where they need to go is not to jail, but to the emergency room. And then I got late night calls telling me, would you mind setting aside the warrant so we can take this person to the hospital? If the person is taken into custody and the police take them to jail after they've been placed under arrest, then the county's responsible for the cost of their medical care. And the county doesn't want to have to pay for everybody who gets themselves arrested that may require medical care. So there's a lot of moving parts and a lot of different factors that play into what happens in that scenario.
Thank you. Warrants issued in civil cases?
On civil cases?
Yes.
In certain instances, yes. They are what are called contempt of court warrants, where the court may find someone has, on a civil case, has failed to do what they were asked, and there might be a contempt citation and an accompanying warrant with that. So yeah, there are certain types of civil cases where an arrest warrant can be issued.
Okay. And in situations like that, can they also end up being locked up if they don't comply?
Yes, they can.
Okay. Bonds also issued on cases like that, or it's different from a criminal case?
Bonds are issued, yes, or bonds are set in most instances.
Okay. You also, you say you taught at Columbus State Community College for
Yes.
how many years? 32?
32 long, grueling. No, actually, I'm kidding when I say that. So I mentioned to you and your audience that I started off my legal career as an assistant prosecuting attorney. It was one of the lowest paid positions as a new attorney. I was married, had 2 children, finances were tight. So after a couple years of being a lawyer working in the prosecutor's office, I sought ways to supplement my income. And I had an opportunity to start teaching at then it was called a junior college instead of a community college. Some people called it a technical college, but I had an opportunity to start teaching there to supplement my income. And so I taught for 2 or 3 years, ended up taking the second job with the Ohio Supreme Court. My income, it improved. And so I no longer needed to teach to supplement my income, but I continued to teach. And at that point, everything I earned teaching part-time, I funneled it into a scholarship fund in my name at my Akron area high school alma mater. And I started giving away scholarships to needy, deserving students who were African American, who were trade students, not just carpentry students as I was, but it could have been students who were in auto body, auto mechanic, nursing, drafting, printing, whatever the trade was. And if they filled out one of my scholarship applications and they were approved, I would write them a scholarship check, and it was fully funded by my part-time earnings at Columbus State. And I did that for probably about 12 years. And at the end of the 12 years, they closed down my Akron area high school, just shut it down, and that ended that scholarship. So I continue to teach, and I have found various other ways to spend that money since the scholarship was closed up.
Wow.
It was very rewarding for those 12 years.
Yeah. And most of your students describe you as energetic, interesting, fun, and enthusiastic. I can also say that you are fun to, in the courtroom. You like to explain issues, ask questions, and also, give advice, even when counsel doesn't know what they're doing or what they're talking
about. Wait a minute. How do you know what my students said about me?
I do my research.
Uh-oh.
So my question to you is, Where do you get all this energy from?
Okay, so I would imagine if we flip the script here and we start talking about you and your career, you've probably been motivated to do many of the things that you do now based on prior experiences that you've had, your family upbringing, maybe some abuses in our justice system that you either experienced or you knew others to experience. And so that was kind of a driving force for you. My guess is the person that I know probably feels that being a lawyer and doing the kind of practice that you do was a calling for you. So it was for me. Most of the things I've done professionally were not things that I just said, oh, I think I'll go out and do A, B, and C. They were things where I felt a calling to do those things. And when you're called to do something, it doesn't take as much energy if you're fulfilling your calling. Because at that point, you're simply doing what you believe you're called upon to do. So for me, especially as a lawyer and now as a judge, what I'm doing is so far removed from anything I ever expected to do. I know beyond a shadow of a doubt I'm where I'm supposed to be. I'm doing the things that I was called to do. And you have energy to do that. You think about people who they pursue their passions. It could be professional athletes or entertainers. It could be philanthropists, people who are all about charitable giving and helping others, Oprah Winfrey and others. And so much of what they do, they would probably say it doesn't require a tremendous amount of energy because they're passionate about it. That's what they're supposed to do. I think about being a parent. Being a parent is one of the most taxing experiences that one can have, especially of small children and especially of teenage children. Requires a lot of energy. But you find the energy without even realizing it to do what you need to do because as a parent, that's what you're supposed to do. And most of us had either good example as parents or bad example as parents. And if you had bad example of parents and you become a parent, you're probably going to want to do a better job than your parents did. If you had great examples for parents and you become a parent, you're probably going to want to maintain that standard and try to live up to the example that your parents set. So either way, as a parent, you're motivated. As a professional, I've been motivated because I feel like I've been placed in this position to be of service. And you dig deep and you find the energy.
Yeah. Thank you for answering the call and for being a beacon of hope to a lot of people. On behalf of the people of Franklin County, I have to say thank you. And even, I'm thanking you myself because I know you have made a positive impact in my life, in my career. And, as you've been a mentor. You're one of those judges that showed me the way, even when I was a young attorney, fresh out of law school. I thank you for that, for lifting other leaders. And thank you for coming on the show and for answering all these questions. I know you're a very busy person, but you carved out this time to do this. Thank you.
You're very welcome. And again, I appreciate the opportunity and I really appreciate and respect what you do as well.
Thank you. And for those of you watching at home or listening to the podcast, thank you for joining us. Until next time, stay blessed.
Take care.